All right, it looks like it's about that time, so I'm going to begin the webinar in 1 second. I just need to get everything into place, so I'm ready for you. The screen should be up and showing, so welcome everyone to the Micklin Law Group's monthly webinar series. The webinar for tonight is called Divorce and Domestic Violence. Be prepared for what comes up in court. You should be seeing this on the screen, so I'm going to ask anybody that's paying attention to just send me a quick note. You'll see you have a control panel on the right side of your screen. Go down to either the questions. That's probably the best section. Just type in this, make sure that you're able to see this video. It should be showing my main screen, so I'd just like to make sure before we go. All right, well, not seeing any problems, and the audio seems to be good, so we're going to move right along into it for you. I'll give you a little information about what to expect from tonight's webinar in case this is the first time you've attended one. The webinars are always scheduled for 60 minutes. Sometimes they go a little longer, sometimes they're a little shorter. I do my best to stay within that time, but I never really know how much time things are going to take until I start going through it, but I do my best to keep it going. I will stay as long as necessary afterwards to answer any questions that you may have. I do recommend that you put them down first, again, in that same part in your control panel that I showed you, so that when we get to the end of the webinar, you won't have forgotten any of the questions. Real quick, as I kept mentioning, there is the control panel. You should have it on the right side of your screen. The webinar is a one-way communication, so you hopefully can hear me. I won't be able to hear you, which is why I suggest typing any comments you have into the question pane. I don't usually check it during the webinar, but once in a great while I do. It usually just takes a little more coordination than I want to have while I'm trying to go through the material. But again, if there's ever an audio or visual problem, type it into there so that hopefully I get to see it and correct it as we go along. For those who don't know me, give you a little background. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I'm a member, actually this is wrong, I'm a member of New Jersey and Pennsylvania State Bar. They must have edited that out by mistake. I'm licensed to appear in both state and federal courts. I began my legal career as a judicial law clerk to Judge Austin in Bergen County. I then went to Kessler & Associates and did complex commercial litigation for a number of years before opening my practice, I believe in 2001, as a general practice attorney at that time, and then I quickly concentrated my practice into divorce, family law, and estate planning and litigation, which is what the Micklin Law Group is focused on. I handle most of the complex and high conflict cases, but the firm itself does focus in those 3 or 4 areas specifically. Real quick, you'll also notice before we move into, actually, I'll forget that 1 second. Here's some background on me, some of the recent awards I've received. I don't put these up here to brag or boast. I put them up because those who have not worked with me, who may in the future, or even those that are currently working with me, should want to know that I have at least the experience necessary to educate you on these topics and to handle your matters. You'll see the ones on the left of the screen are my more recent awards, the American Academy of Trial Attorneys, the nation's top 1%. The ones in the middle, the AVO rating is now a 10.0 out of 10. That's a company that does an independent algorithm to rank attorneys independently. The one on the bottom. And the one on the right are awards I've received several years in the past. One's from Martin Del Hubble, which is a very large, I think the largest legal resource and research company in the world, and AVA, which I was mentioning back there, also the Excellent Rated Attorney Awards. Real quick, before we go into what we're going to cover, as I was starting to say a moment ago, on the bottom right part of your panel, you'll see some handouts. The first is a handout of this PowerPoint in case for some reason you would like it. Now, it's about 65 pages, but there are going to be certain pages that have certain cases and statutes that are referenced that may be helpful to you. The second one is a temporary restraining order guide. It's a PDF which walks through the different parts of a restraining order application. The guide, I believe, was created for police officers as a reference and educational tool. I'm giving it to you because it's helpful to know what they're going to do when you come in to get a temporary restraining order, whether it's with the police department or in the family court. And then later when we get to a certain point, I'll show you certain parts of the application or the temporary orders that are very important to keep an eye on. So let's take a minute and look at what we're going to cover. First is what is domestic violence, the different acts, and the case law. You'll learn there are many different elements to establishing both a temporary and a final order. It's not just having an act committed against you. It's a lot more complex than that. Next, we'll talk about the temporary restraining order, which is the first step. How you receive a temporary order, the different methods of it, and also the pitfalls that are often experienced both in getting the temporary and then when you go to apply for your final, which also goes back to the handout I was telling you on the bottom right there. Domestic violence trial, which will occur at some point after you get your temporary. We'll talk a little bit about excuse me, how you need to prepare, what you can expect, which is probably the most important, because this webinar is not necessarily just for victims of domestic violence, but this is also for those that are accused of committing acts of domestic violence. It's very helpful to know what's going to happen to you. A lot of people think it's just a matter of telling the truth when you go to court. Unfortunately, it's not. To all my clients, it's a matter of how you tell the truth. And we'll go into a little bit of that when we get to that portion as to why and what's going to be necessary for you. Talk about the final restraining order, which is the last step, the relief that you're going to be asking for and what you can expect both at the trial and in the final order. Dissolution of a final restraining order, how to dissolve it. It's a sort of misnomer that's called a final restraining order, although technically it is still considered final in New Jersey. We are one of the last states, I think Washington may be the only other one that does offer a permanent final restraining order, but it can be dissolved, and we'll go through what it takes to do that. We'll also talk about a civil restraining order, which is just an option. It's an alternate relief for those that either can't get a restraining order or for certain reasons may not want a final order. So we'll talk about that and the other option and how it differs from the restraining order. All right, so what is domestic violence? Let's go through first. Now, you'll see there's going to be a lot of statutory provisions that I am not going to cover specifically. I'm going to cover just on the important ones. But domestic violence has to have one or more of the following criminal acts. And what they did was they incorporated the criminal statute into the domestic violence statute. So any of these enumerated, and this is not all of them, this is just the first batch I'm giving to you, so you can take it in piecemeal. Any one of these enumerated acts can constitute domestic violence. I'm going to give you some definitions of what some of these are, the more common ones. Assault, obviously, is a physical or unlawful touching of a person or striking. Terroristic threats is a person threats an act with the purpose to terrorize the other person. Criminal restraint is when somebody restraint that exposes somebody to bodily injury or involuntary servitude, like a forced action or a servant type of relationship. False imprisonment is a restraint that interferes with somebody's personal liberty. It's in many ways a little less than a criminal restraint in its duration and its significance, but obviously still a criminal act. And then sexual assault, which can be one of many different forms of inappropriate or unlawful sexual conduct or contact. The next part, criminal mischief, 3 down. Another common one that you'll often see as grounds for restraining orders, purposely damaging person or property. This is an important one. I think a lot of people, when they fill out temporary restraining orders, don't think to include this. Please also it's important to keep that one in mind, because that may often strengthen what may otherwise be a weak claim for a final restraining order. Burglary, and criminal, actually burglary I'm not going to go into, it's not a very common one, but criminal trespass is entering a property or place when the person knows that they are not welcomed. So if you say don't come by, stay away, get out, it's criminal trespass. Another one that is not commonly used but should be, would strengthen your ability to get a restraining order when we talk about the elements you need to prove a little later. Keep these comments in mind. Harassment simply is the intent to harass or the purpose to harass. And then stalking is maintaining a visual or physical proximity to another person. Also a very common act that's used for a restraining order. It's very important The ones I point out that aren't used often are also very common: criminal mischief, criminal trespass, very common when somebody's damaging property or pushing in a door. And they're easier to establish than the harassing or assault. Maybe the proof is a little easier. So people need to start using them, I think, a little more than they do right now. So please, if you are the victim, please keep that in mind when we go through the parts about filling out for a temporary restraining order. So let's talk about a little bit about the domestic violence case law. It all began with the Prevention of Domestic Violence Act of 1991. Essentially, the reason why we have domestic violence acts that track the language of criminal acts is because historically police wouldn't get involved in what was reported as domestic violence because they considered it a family matter, and they often left victims without a remedy. So we had to separate the criminal law and the family law, and that was largely accomplished with the Prevention of Domestic Violence Act. Following that, there was the Violence Against Women Act, which gave full faith and credit provisions. What this enabled states to do was to recognize domestic violence of other states. So you may have somebody who lives in Pennsylvania, has to flee Pennsylvania to avoid the domestic violence, but would have had trouble getting an order in New Jersey because they're not a resident here, or the act did not occur here. There's also issues if you have a restraining order in Pennsylvania and you come to New Jersey, the time that would normally take to have registered and gained full faith and credit, or the one state recognizing another, was a very arduous and difficult process. This statute allowed for greater and faster interstate protections for victims of domestic violence. And then one of the most significant cases that we'll talk about here is Cesar versus Cesar. It's a very meaningful case in the body of law for domestic violence. One of the main important things that it held is that a single act of domestic violence can constitute the need for a final order. So even one simple act, not simple, but one act of harassment or criminal trespass, for instance, even without a history, can be sufficient to receive a domestic violence restraining order, which is also important to know. A lot of people are dissuaded from seeking protection because they're told it has to be physical harm or there's not enough history. None of that's the case. Cesar versus Cesar clearly points that out. Next significant case, Silver versus Silver. This is what talks about what you need to establish to get a restraining order. First of all, it defines what a qualified victim is. Historically, that was a family member, a spouse. It's now being expanded. I think there's some cases that allow landlords even to fall within there. Now, brother and sister siblings relationships, it's no longer just an intimate partnership. And essentially, Silver versus Silver, the importance of Silver versus Silver is that it expounded a two-pronged test that a court needs to find to grant anybody a restraining order. The first is they have to find that an act of domestic violence occurred, which brings us back to the first couple slides where I showed you the different acts. Now, once you've established that one of those acts have occurred, and remember I said to use the ones that are easier to prove, criminal mischief, criminal trespass, that are not common because it helps you establish that first prong. But then the second prong that Silver versus Silver said a judge must find to grant an order is that there's a need for ongoing protection, which takes you out of the realm of that one act being sufficient. Now it made it a little more challenging. And basically you need to establish that even if it is one act, why that one act suggests that you need permanent protection. It could be simply that you were just terrified for your life. It could be that you used to be coworkers and you need to make sure that that person can't return to your work. You may share children in common and you're going to have an ongoing continuing relationship with this person. These are all reasons that would go to that second prong, but you must be able to establish both before a judge can give a final restraining order to anybody. HES versus JCS. One of probably my most utilized cases. I don't remember the year, but it's not very old. And it basically says simply that the domestic violence process must yield to due process requirements, which basically means there's got to be notice and an opportunity to be heard, both before and at the hearing. So before, that means you have to be served with a restraining order in proper time. You need to have an adequate time to respond and prepare a defense. It suggests if you come and need an attorney that you should be granted an adjournment or a rescheduling of the first day to get an attorney. But it also held something very interesting, and that was that acts that occurred after the restraining order is granted can be utilized in establishing the need for a restraining order. I won't go through the whole specifics of it because it's a little more in deep than this review requires, but it's basically used as the history would be used. So it doesn't establish the act of domestic violence, but it can go to establishing the second prong of silver, which says the need for protection of a restraining order. If somebody's violating the order, for instance, after it's issued, that's a strong indication that they'll need this protection going forward because the person that's violating it just can't be controlled, for instance. All right, so let's look at a temporary restraining order. This is the first step in the process. It may be entered against a defendant who has been alleged to have committed domestic violence. It's not a very challenging threshold. Later we'll talk about how you apply for one, but in my experience, you almost always get them when you apply for them, which may or may not be the best thing for our legal processing community, but that is the way that it is right now. I've seen very few, if any, occasions where a person has gone for a temporary restraining order and been denied it. Now, one thing to know, most people don't realize about the temporary order is that there is an appeal process, because a temporary order is a very swift, very harsh remedy in some circumstances. It takes you often out of your house, takes you away from your children, could take you away from your business if you run it out of your house. So what exists that most people aren't aware of is there is a 2-day appeal process where if you're served with a restraining order that may not be heard for another 10 days or maybe even longer, you have the ability and the right to go to court and have a judge in the Superior Court listen to your appeal and say why it's not valid. Perhaps you weren't home and the allegations are false, or it's even in the face of the paperwork that received that they didn't allege an act of domestic violence. There's a lot of reasons why you might be able to successfully appeal that. Now, I haven't seen many people do it because the hearings are usually very quick. They're usually relatively quick. They're usually 7 to 10 days after the temporary, but as we'll see later, that's not necessarily always the case. So like I was saying, they're supposed to be returnable in 10 days, but in my experience, it doesn't really usually happen that quickly. Now let's talk about some of the things that will give temporary relief, and the temporary relief will stay in place through and including the final restraining order. I point this out because, and I think we talk about it a little bit later too, but yeah, we do. It's very important to think about what you're going to need. I know usually when you're seeking a restraining order, it's an emergency situation, but many people have been involved in the situation before actually calling for one, so it's not a great surprise that they need this protection. You need to contemplate what you may need. Even speak to an attorney if you had an ongoing domestic violence problem as a consultation for future reference, so you know the things that you need to ask about or for the temporary relief. So let's go to that prong I was telling you in silver versus silver, the need for future protection. Very important aspect when you go to the actual end trial. You must show, as I said, the need for future protection, and that can be, like I said, through subsequent acts. It can be through the history. It can just be through the act that's complained of, but it's going to be a necessary portion. The obviously intent is to protect the victim from future acts. Now, so that carries us into getting the TRO. Like I was saying, what's important to realize about the restraining order is it is available 24 hours a day, 7 days a week. I point this out because a lot of people go to, and I apologize to anybody that is a police officer or knows or somehow related to a police officer, but a lot of people will go to the police department and ask for a restraining order and be told that they're not allowed to get one, or that you have to go to the family court the next day, and that's bogus. There's somebody available 24 hours a day, 7 days a week in every town to get one. So there's a sense, let's look at how you get one. There's 2 ways. The first way, and probably the least common way, believe it or not, is in the Superior Court Chancery Division family part of the main courthouse in the county that either you're living at, or more likely the the county where the act of domestic violence occurred. I recommend to everybody who has this type of situation or concern that you get the address to the courthouse now, that you become familiar with where it is in case you need to get there quickly in some circumstances. So let's look at the specifics of filing in court. It is during normal business hours, regular court hours, which are supposed to be 8:30 to 4:30. Lunch is usually at 12:30 to 1:30. In my experience, not much happens at 8:30 and not much happens at 4:30, and lunch doesn't end at 1:30. So get there as early as you can and be prepared to be there as long as you can. It can only be granted by a Superior Court judge or domestic violence hearing officer. They, again, are always on staff when the courthouse is open. But a final one can only be entered by a Superior Court judge. We're talking about the temporary ones. So don't get confused between the process for getting a temporary and the final. Temporary is, like I said, a lot easier than the final is going to be. Now, the other way is municipal court. This is probably the more common way that most people get it just because of the nature of domestic violence. Municipal court is after hours, weekends, holidays, whenever the courthouses are closed. And you do that essentially by calling the police department or going to the police department and indicating what the act that occurred and that you want a restraining order. As I start to talk about in the history of domestic violence, a lot of police officers will dissuade a victim of domestic violence. I think part of the reason is because they might not have the training that's necessary to really recognize that. Again, historically, it's been treated as a family matter. I think sometimes if it's late at night or on a holiday, they don't want to get the judge involved, because in order to get a restraining order, what they do is there's a Superior Court judge that's on call, and it's considered the emergent duty judge. And there's always one in every, I don't know if it's every town or every county. I think it's every town. And the police are able and required to get the judge on the phone, give the allegation of the restraining order, and seek to have one temporary issued. You have an absolute right at any time to demand to speak to a judge to get a restraining order if you believe you're a victim of domestic violence. I can't urge that enough. All right, so let's look at the form. And here's where I mentioned that that handout is going to come in very helpful, because there's often a lot of difficulties when you don't know how to fill out the form, and if you get a police officer that may either not know or because there's limited space or time, may not be filling it out properly. So I'm going to take a minute or two to talk about some of the parts that I think are going to be most important. I'll try to get my pen up here. All right, so the first part to become familiar with is right here. This is where you're going to, or they're going to write in the act of domestic violence that occurred. Now, a couple of things. First of all, if you are a victim of domestic violence, I recommend that you go for a restraining order as soon as you can, because what's very important when the police look, or not the police, the judge looks at your act of domestic violence, they'll look at the date, which would be right here, that you filed, or that you're complaining the act occurred, and the date here that you actually sought the restraining order. If there's a gap, a big gap, it goes to that issue of, do you need the protection of, do you need an ongoing protection? If you waited, it suggests that you weren't that concerned for your safety. So go as soon as you can. Now, what I'm going to say next may be a conflict to that, and that is when you complain in here, not complain, but that's what the legal term is. Complaining of the act of domestic violence does not need to be one act, and it does not need to be limited to one day. If you've been in a problem over the last week where 3 days that you encountered the other person, there was domestic violence, or you have, ongoing since a certain occurrence, like a change of job or a birth of a child, you can put more than one day in here. And that's important because this is the first part of that silver test, finding that an act of domestic violence occurred. It does not have to be one act, but if you put in one act here and then the rest you talk about as a history, if the one act that you put is not sufficient, then your whole case will fail. So if you can convince the officer or whomever's filling out your paperwork to put several days or several instances of domestic violence into this first part here, which I don't believe actually has a number, but it's the history of domestic violence. The next is the acts, or the criminal acts that will be alleged. Now remember, I was telling you, I know it's not very clear, but after you give them the acts here, they will usually, the police or the domestic violence officer will usually pick the ones here that sound like they're violated. And I know it's not clear, but going back, the most common ones are harassment and terroristic threats. I don't see people checking off criminal mischief, criminal trespass, and I would urge people to do that. Even if you get it from the police officer or the judge and it doesn't have that, give it back to them and tell them that you want it to be marked with those, because those acts will be easier to prove. And that goes to your first prong. And we'll talk a little bit later about the problems if that isn't done that way. Now, the next thing, and this is very important, question number one, which is right here, question number one, fills in this whole box right here, is the history of domestic violence. Is there a history of domestic violence? Yes or no? I see a lot of people checking off no. And the reason that, even when there's a significant ongoing chronic history of domestic violence, the reason they're checking off no is because I think a lot of people read this question and believe it means legal domestic violence, like a restraining order, a trial, some kind of court finding that an act of domestic occurred, a municipal court criminal case. That's not what this question means. This means anything that you consider to be domestic violence that's happened in your past. You want to be as specific as you can. You want to put in as many dates as you can. You may want to take some time before you go, if you have the time, before you go and fill out the temporary restraining order, to think back about the history so that you'll be familiar with the facts that need to go in there. And when you go, and whether you're talking to the police or you're talking to judges, don't be afraid of them. Don't worry that you feel uncomfortable telling them that they forgot to put something in that you told them, because if you don't put it in, you may not be able to talk about it, and that may affect your ability to receive a final restraining order. Now, when you're going for a restraining order, let's talk about kind of relief you want to get, because there's nothing that limits what you can ask for, and even though they say it's going to be heard in 10 days, we don't know that it's going to be heard in 10 days. So ask for anything that you think you're going to need. So first, custody, possession of the residence, and some temporary support. Essentially, that's always going to be no contact to you, your children, and any third parties like relatives, employers, other partners, domestic partners, friends. With children, it's sometimes a little complicated. Generally, the restraining orders will prohibit all contact with children. And you might want to specify whether or not you agree to that, whether or not you agree to, say, text messaging to the children in the interim. It's a personal choice. Most judges will have no contact because it's usually just safer. Not only keeps the children out of harm's way, but it keeps from any accidental violation of the restraining order. Possession of the residence, very important. 99.9% of the time, the courts will grant you possession of the residence that you share, regardless of the situation, the factual situation. Like if it's like, if you're living in his mother's house, for instance, that's an awkward situation. Now, if you're sharing a residence with his mother, that also becomes problematic. But in the average situation, it's not that kind of a case. You will have temporary possession of your residence, even if the defendant is running a business out of the residence. They will generally still take out and give possession because it's a very swift, harsh remedy, but it's also supposed to be very short term. Emergency support for yourself or your children. I always tell people, think about what you're going to need over the next couple of months, because you have no idea what's going to happen after you get this temporary order in place. Ask for weekly support for you and the children. Ask that they continue paying rent or car payments or whatever they may have in the past. Try not to have it be general, like judges will use things like roof expenses. That's not real clear to a lot of people. That should mean mortgage or rent payments, utilities, upkeep. I like it to say that. Instead of getting roof expenses, I love to take 5 minutes and write out mortgage payments, utility payments, taxes, utilities, water, cable, cell phone. Spell it out and make sure, and extra money also for yourself and for the children. Make sure that everything you need is going to be taken care of. Temporary custody of the children and medical coverage. Temporary custody, again, as I alluded to, is generally going to be given to the victim, and there's usually not going to be any contact to the defendant. Medical coverage, I think it's important just because you want to make sure it's in place Make sure it's ordered that it's to be continued and paid for in the hiatus between filing the temporary and getting into court for the final one. I'm doing double at a time, so I don't want to keep it too much over time. Limitation on parenting time. Again, custody and parenting time are very different. You will get temporary custody, whether the court gives parenting time, some call it visitation still, is generally not given, but you may want it. You may think it's okay for the children. I don't recommend it. I think it sends a bad message both to the defendant and to the judge that maybe there's not a great fear. And here also, law enforcement accompanied by either party to remove personal belongings. The defendant is being taken out of the house. They're probably going to need to have some items removed. You want to make sure that there's like what we call a peacekeeping officer that is there and assists. Expect that this may happen once or twice. If they're trying more than twice, then you have somebody who's probably trying to exert some control here, trying to get back to the house 4 different times to get their stuff. That you don't need to permit. Once or twice is more than enough. After that, I suggest that you tell the police officers you're no longer willing to let them retrieve their personal stuff. If you're the defendant and you're going to have problems getting things or you have a lot to get, then take my advice to the contrary and ask on your appeal process to have a couple days to get in there because it may be some time before you get a final decision. The next things are the abusing spouse cannot possess a firearm. That's standard now for reasons I won't go into in this webinar, but it's routine. It often is problematic if you are a law enforcement officer, but unfortunately it's too bad there's very little to do except for the appeal process that I mentioned before. And monetary relief, like I talked about before, to be very specific. One thing that's not on here, and it's because you don't necessarily need to get it with a temporary order or even at the final, but there's a period of time, I think it may be 2 years, but I always recommend you go quickly after your final restraining order. And that's to the Violent Crimes Compensation Board, the BCCB. It's a board that was created to compensate victims of domestic violence. So it helps pay for or reimburse for legal fees, medical fees, damages you may have suffered by being a victim. It's a very, very outstanding organization that most people don't seem to take advantage of. So if you are or were a domestic violence victim, I would certainly recommend that you look into the BCCB and see what kind of relief they provide. All right, so let's move into the domestic trials, what to expect, how to prepare. First, prepare for an adjournment. And that means prepare that the day you go to court is not going to be your final hearing. Either you go there and you realize that the other spouse, the defendant, has an attorney. Now you want an attorney. That defendant can go and say, I need an attorney and get a hearing. You might find out that they didn't serve the paperwork. That whatever it may be, more often than not, the first one gets adjourned. It's also not surprising for it to happen a couple times. So there may be, if you're a defendant, you may go there and find out that the plaintiff added new allegations and amended her restraining order. And now that has to be served. If you're the plaintiff and you filed the restraining order, you might find that the defendant filed one against you, and now that's got to be served on you, so there's a new hearing. It gets moved. A lot can come up. In my experience, the level of sophisticated domestic violence cases, meaning socioeconomic class of people seeking restraining orders and having lawyers, it usually is not going to be your first one. You want to review your complaint, whether you're the plaintiff or the defendant. You want to be, if you're the plaintiff, you want to be familiar with the date and time. You want to know what day of the week it was. You want to know what you said. You want to know what you wrote. You want, when you're asked about it, you're not going to be able to read from the restraining order unless you can't remember, maybe. But you also want to check all these things because some of the information could be incomplete or inaccurate, and you didn't realize it when it was being filled out because it was late at night or because a police officer did it, and you may need to change it. You may need to amend it. If you're the defendant, similar kind of advice. You want to know the dates they're claiming. You want to see where you were. You want to check for receipts and get witnesses. So you really want to know what's in the complaint. Review the calendar. Sorry, that's what I was saying. Confirm the dates. Make sure that you recall where you were, who was there. Consistent recollection is very important on either side of a domestic violence case. Next, must. must bring witnesses. People seem to think that I can bring a writing, or I'll tell them from my recollection, writings are inadmissible. Police reports cannot be admitted without the police officer. Witnesses can be the key to success because nothing else is going to be admitted. And with domestic violence, the problem is often there aren't witnesses to it. So when you go, the judge is going to be listening for consistency in testimony, credibility. That's why I was saying when you go back, reviewing the complaint and the calendar, because you want to be consistent and credible. You want to know your dates and remember everything. But you want to have witnesses, because if there's somebody else, that person is more likely to have more credibility than the plaintiff or defendant, because each of you have something to gain or lose in a restraining order. Witnesses are key to being successful on either side of a domestic violence complaint. All right, so let's talk about the final restraining order. Violation may result in the defendant's arrest. This can be before a final order is entered. More often than not, if the allegations of the domestic violence temporary order are serious or allege physical abuse, I believe it's automatic that they get arrested. If there's signs of physical abuse, bruising, cuts, maybe damaged property, I believe it's automatic that New Jersey police officers arrest you. I think New York is automatic that you're arrested, period, for allegations of domestic violence, but I'm not sure. But it's damaging. There also will be civil sanctions. There are law enforcement penalties. You will also be there's a couple of penalties, and I'm sorry that I don't remember the specifics, but there's usually between $50 and $200 worth of penalties. Sometimes there's criminal sanctions if the final order is granted against you. That's not too common. I haven't seen that too often. More often than not, what you'll see, there's fingerprinting. There's also a central database that the defendants go into, so that if you have a final order that's registered in New Jersey and Bergen County, but you take a trip down to Cape May County police officers are also able to find that you have a restraining order, so you don't need to have it on you at all times. Very important part. Also becomes very problematic for international travel and things like that. So let's turn on to the relief and how that may or may not be different from the temporary order that you would be seeking. Just give me 1 second. I need to sip my coffee. Just going to take a check in to make sure audio and sound is okay. I don't see any messages. For those that may have signed on late, this is being recorded, so you'll be able to get this on my website. But there are also handouts on the right side of the control panel. On the bottom, there's the Divorce and Domestic Violence. That's the PowerPoint that you're actually watching. I caution you not to print it necessarily. There's like 60, 70 pages to it, but and of course you're free to. But there's also the citations. You may want to get the cases. Just print those pages if that's what you're interested in. And the Domestic Violence Guide, which is a police officer's reference guide of how to complete a restraining order. That's there so that you can go and see what the police are supposed to be doing with you. One, to make sure they're doing it correctly, and two, to make sure that you know what you're doing when you get there, because they're going to be following your lead in many instances. So turning back to final restraining order relief. First is going to be no contact to you, the children, third parties, possession of the residence. That's almost a given. Again, not necessarily as certain as the temporary order. Usually, I'm talking about the residents. No contact with you is a given. No contact with any third party that you feel necessary, as long as there's a rational basis for it. And more than likely than not, you will not only get custody of the children, but you will get sole custody. A final restraining order carries with it a presumption of sole custody in your favor. And even though judges are reluctant to grant even sole custody in that instance, it's presumed, and you have every right to seek it and to ask that the order be entered. Possession of the residence, again, this is almost a certainty unless you have the not unique, but the less common situations like you're sharing the residence, and maybe the defendant's spouse or the defendant's mother or the defendant runs a business out that can't be moved. But if that's the case, then you may need to consider the the support issues differently. So when you're talking about support issues for you and your children, you may need to work in the housing costs. You can ask for ongoing support, and you should ask for ongoing support, like I was saying in the temporary order. Specific roof expenses, specific bills, medical insurance, make sure that it's spelled out. Again, the custody of children, it's already touched upon, medical coverage and parenting time. This is all, like I said a moment ago, it's almost identical to a temporary order, but I think you want it to be, not I think, I know you want it to be more specific when you get to this stage, because this is the end of the line. You're not coming back, most likely. So you want to make sure that everything is spelled out properly for you. Again, law enforcement to supervise the removal of property. The abusing spouse can't possess a firearm. I don't know whether or not an exception can be made for police officers. I've only seen it done in one case, and it was sometime after the restraining order had been granted, and the police officer was allowed to have his weapon during business hours. He had to pick it up at the start of his shift. He had to turn it in at the end of the shift. And that may have been an aberration. I'm not sure now, and this was many years ago, if it's permitted or not. I believe it probably would be, but you would need extenuating circumstances. Simply being a police officer is not going to be enough, because if you've committed an act of domestic violence, the court's going to say, well, you should have known better, and this is the price that you pay. So if you're a defendant and you're a police officer, you need to be careful in these kind of relationships, and we'll talk about some alternative processes to help eliminate that issue should it arise for you. Monetary relief, I think we've covered that. Anger management, this is important. Actually, I'm going to move to the next couple slides here, because anger management, risk assessment, drug tests. These are most important, and a lot of times they're overlooked because people are thinking, well, I got the order, that's all I needed. But if you have any reason to think you're going to have an ongoing relationship with the defendant, husband and spouse, ex-husband and spouse, children in common, you live close together, you work close together, whatever the reason may be, especially if you have children, without a doubt, you want to ask for, and sometimes you do it automatically, but you want to ask for these types of issues to be addressed. Now, they're going to vary depending on the nature of the person and the acts complained of. Anger management is almost a given. Anybody who's committed an act of domestic violence obviously has anger management problems. Risk assessment, more often, if there's children, they want to see if they're a risk to the children. Drug tests and assessments, if there's allegations of abuse, even if it's not an addiction issue, but just a usage issue. You still may want to have them tested. You may want to get an assessment to see how chronic and severe the use is, especially if you share children in common. You're going to have an ongoing relationship. You want to ask that these issues be resolved. So now let's turn to the part that doesn't make most sense, and that's dissolution of a final order. And I say that because if it's final, then why is there provision for dissolution? And as I said, Jersey is one of the few states that still considers it final. I know Pennsylvania, for instance, they issue it for a time period and it expires by its own terms. I don't know whether or not I think that's good or bad. I guess in certain circumstances it would be good. I think the slippery slope is that New Jersey will soon abandon that permanent order and go to something like Pennsylvania, where it can be expired by its own terms, or maybe they'll create a situation giving a court discretion. But the move along the rest of the country is to make it not permanent. So I think it's only a matter of time before we see that. So a couple ways you can dissolve it. One, by consent, agreeing to it, and you would still have to go into court and dissolve it. And the court would, I believe, are required to send you to or offer you counseling sessions. And before they dismiss you, you have to attend up to 3 counseling sessions. And the purpose of the counseling session is to make sure that you're doing it voluntarily, that you're not being coerced. Even if it's not an actual coercion by the defendant, maybe it's economic coercion, or maybe it's you feel bad for your children. There could be countless reasons why you're being pressured into agreeing to it. So they offer the counseling sessions to make sure that you do have the right to refuse the counseling sessions. I don't think it's in your best interest. There's nothing to gain other than saving some time by not having these sessions, but nonetheless. And it can be by a court order. Obviously, it's entered by a court order, so it can be dissolved by a court order. Now, what needs to be shown in order to do that is defined under a case called Cafagno versus Cafagno, or Cafagno, depending on where you're from. This has a significant amount of issues that need to be established or the court is supposed to look at. Not all of them will necessarily apply, but the court has to consider each and every one of them. First is whether or not you consent, the plaintiff, I should say. Victim's consent. Second is the victim's fear of the defendant. Now, this is defined by case law as a reasonable person standard, which means it's not, although it's written this way, it's not whether or not the victim actually fears the defendant. It's whether or not a reasonable person in the plaintiff's position would still fear the defendant. It's a much more difficult burden, but it's the way the case law currently stands. The nature of relationship between the parties, that's going to be a lot of different factors, like do they have children in common? Do they live together? Are they married? Number of times the defendant has been convicted of contempt of the restraining order. Hopefully, in most cases, that's not going to be any, but they're still required to look at it, determine it. Next is drug or alcohol abuse, both in the underlying temporary order and currently. Next is other violent acts with other persons. This is important and can be difficult. A lot of times, a plaintiff will know of allegations or other restraining orders that the defendant has against him or her from other relationships, but they don't think to get information about that before going for the temporary order. And it would be important in seeking your temporary, definitely important to bring up if and when the defendant seeks dissolution of it. And I say that to bring it up and plan in advance because restraining orders, the pleadings are confidential. You can't just go to court under Public Notice Act and get the documents. You need court permission to get them. You usually but it's helpful to have an attorney. But you want to get them before or as part of the response if they file a motion for dissolution. Whether or not there's been counseling. Now, sometimes counseling is not even ordered in the final order, but that doesn't mean that the defendant can't have got it on his or her own. It also means that if you're the plaintiff, you can argue that they should have if they're the ones seeking the dissolution. Age and health of the defendant. Whether the victim is acting in good faith. I have a little problem with this, but it's the way the statute is written. If you have a restraining order, in my opinion, wanting to keep it is always good faith. But nonetheless, there can be suggestions that somebody's less than good faith, like they're using it now for their own coercion, like if the defendant is a police officer, or if they're using it years later to still thwart parenting time, or to get economic support. There's a lot of reasons you could be using it in bad faith. I just don't find them very common, and I'm not really crazy about the fact that this provision's in the statute. But whether or not there's another restraining order in a different jurisdiction, that goes back to what I was saying before, that a lot of times you'll know about past acts with other partners, but you need to get that. And then the catch-all that we always find, any factors deemed relevant by the court. That's good and bad depending on where you're standing in the case. Most statutes will have that. Family court is what's called a court of equity. So that means that the courts look broader than the black letter of the law. So you'll often see statutes having this provision in it. Now, I talked about this in the beginning, a civil restraining order. It's an alternate remedy for those that need some kind of protection of a restraining order, but for one reason or another don't want it final. It could be that you're not likely to receive a final if the allegations aren't sufficient, or if the relationship doesn't, if the acts don't really rise to the level. There might not be enough history to prove the need for ongoing. The defendant could be a police officer, and your need for support is great, and that police officer may lose his or her job by losing a weapon. So it's a lot of reasons why you would enter a civil restraining order. The language of an order and the restraints would usually be similar, if not identical, to a final order. So you can have restraints and track the same language on contact against you, parenting time restrictions, custody designation, sole custody. If you want sole custody, you have to have it designated in your civil order because this is an agreement. It's a consent order by agreement. So the presumption of sole custody does not come with it, but that can certainly be one of the terms you agree on. The support Again, no different than your temporary and your final. You want to specify exactly what's going to be ordered or paid. Terms regarding your residence. Like I said, everything that you can and should put in here is the same. Usually, this is being entered for some reason. Either the plaintiff is being reasonable or can't win, or the defendant would really suffer by final, or they had a bad situation and they're trying to move on. But don't forget, whichever side of the case you're standing on, that what led to this order may still continue after it. So you need to make sure that the order that you have in place protects you from either harm, and whether you're the plaintiff or the defendant. So you want to be specific in the language. Now, very important difference is this restraining order is not enforced like a final restraining order is. Now, they're both family court orders, but I always explain it as if the family court order is like a criminal order, because if it's violated, it's enforced by the police department, it's enforced by the prosecutor's office, and it's criminal matters. So if you violate a final restraining order, you're prosecuted. It's state versus you, and you're defending a criminal case, and could end up in two violations or two convictions for violating mandatory jail time. A civil restraining order is enforced through the family court, which can mean the same thing. The family court technically has the same powers to arrest, to sanction, to recommend for criminal prosecution. But in my experience, they don't. It's a much slower process because it takes usually a couple months to get in. And judges aren't going to necessarily issue warrants for arrest. And because the civil order usually also suggests that there's not domestic violence, otherwise you wouldn't have entered into it. So I caution people on either side about getting into this. A civil order, it's a great mechanism. A lot of times domestic violence cases erupt because of a troubled relationship, but it doesn't suggest it's an ongoing problem. It just needs to be addressed. These orders are effective for people that have respect for the law. That's how I usually explain it. If somebody believes that signing a consent order will get them in trouble and they're going to follow it, then you do a civil restraining order. If you have either the plaintiff or the defendant and you're the opposite party, and you know that that person doesn't care about paperwork, let's say the restraining order that was followed is bogus, or the defendant is very violent and harassing or menacing, these orders are not likely to be helpful. They're only going to be helpful for people that have respect for the system. So in a lot of cases, if they don't have that, it's not even worth entering into. One of the problems that arises here, and I tell my clients to be very careful about this, if you enter a civil restraining order, that means you don't have a final restraining order. But if you're the victim of domestic violence for another act, you're allowed to call and obviously always seek the protections of a final restraining order. If you are going to do that, do not tell the police officers that you have a civil restraining order in effect. It doesn't matter, because if you're a victim of domestic violence, you have the right to report it and get a restraining order. Once you tell them you have a civil restraining order against that same person, they're going to tell you it's a family matter and you have to go to family court the next day, and then it's going to be months before it gets addressed. It's not what the law says, but I'm telling you that that's how it plays out. So I tell my clients, don't mention it, because you don't need to. You have the right. If you want a protection order immediately, do not mention you have a restraining order. If you happen to be the defendant and the police are coming because there's going to be an order filled out, if you can get to the police department before it's done and tell them you have a civil restraining order, you may be able to negate one being filed against you. That's more difficult, because usually you don't know if something's going to be when somebody's filing against you. And then getting to the police department can also lead you to potential issues of violation. So I don't necessarily recommend it, but something to keep in mind. So the point to take from that is civil restraining orders can interfere with your ease of getting a temporary order. So if you're the plaintiff, don't mention that you have one if you find you're in the need for domestic violence. All right, that wraps up my materials. I'm going to take a sip of my water and then see if we have any questions. All right, so I don't think I see any that are posted. I'll give it another moment. Anybody have any questions? Quickly, just post them up there for me. Okay, go good. Hopefully that means I covered everything that you needed to know. If you happen to think of something once the webinar is over, I'm sure you have my email from the announcements that you got about this. It's also right down here. Actually, let me give you the next slide. This is a better way to contact me. Here's my direct email and my phone number. I believe that family law is not a 9 to 5; it's a 5 to 9, which is why I'm here now. So, if you have an issue or a problem, email me, call that phone number anytime, day or night. It will be forwarded to my cell phone, and you'll get an immediate response when possible. With that, I want to thank you for joining us and for allowing me to present this information to you. We will be having one next month, the last Thursday of every month usually. I'm sorry I don't know the topic offhand. I wish I had looked at my schedule beforehand, but hope to have you join us there too. Have a good night.